on June 13, 2025. So using the gavel, I hereby call to order this meeting of the Oregon Government Ethics Commission. Our Executive Director, Susan Myers, is in the Salem office with staff from the investigative, training, and administrative sections of the commission. Our counsel from the Oregon Department of Justice, Sean Brady, also is in the Salem office. For the record, my name is Dave Fiscum, and I currently serve as chair of the commission, and I am in the Salem office. As for other commissioners, Vice Chair Shanoa Payne is online. Commissioner Dan Mason is online. Commissioner Jonathan Thompson is in the Salem office. Commissioner Rick Burke is online. Commissioner Elisa McCauley is online. Commissioner Ivan Resendez Gutierrez is online. Commissioner Ann Mettler is online, and Commissioner Peter Jancy has been excused today. The attendance means we have a quorum, so we'll proceed first with a few items on our public session agenda and then move into executive session. First, as chair, just a few comments for me for the record. First of all, I want to commend all of my colleagues for their resilience as we all contend with long agendas and as well as monthly meetings. Frankly, I am retired, so I can deal with such a schedule, but for those who are still working full-time, it can be challenging. So you have my thanks and appreciation for staying the course with us. Second, our executive director, Susan Myers, will provide an update on the legislative session as part of her report later in the agenda, including two of our bills that remain alive, plus our budget bill, which also is alive. Third, I hope we can find time soon to discuss a few other issues, including number one, reviewing our current mission statement, which reads as follows. The mission of the Oregon Government Ethics Commission is impartially and effectively to administer and enforce Oregon's government ethics laws for the benefit of Oregon citizens. The commission emphasizes education in achieving its mission. It may be time I submit to make sure this is still an accurate statement of our mission. It can come across as incomplete, if nothing else, because it does not include any mention of our roles regarding the public meetings law, as well as in regulating lobbyists and their clients. Plus, I, for one, want to make sure the statement strikes the right balance we seek between education and enforcement. I include this for at least one reason. I received a text recently from a former legislator, one I lobbied when I worked at the Capitol, who commended us for one of our recent decisions in which we chose to impose a penalty. His concern, he told me, was that he felt education had often topped enforcement for the commission. I am not sure if he's right. Doesn't matter. For me, the balance is critical, and I add that enforcement, for me, is often a way, not the only way, of course, to produce education. So the question is whether our mission statement reflects the proper emphases. Any quick comments on that, colleagues? The mission statement will be under review for a while as a non-emergent issue, but one that's important, and our staff will be taking a crack at drafting a mission statement for us to review at the proper moment. A couple other things that also may be time to review the current penalty matrix to make sure it is also up to date, given the central role the matrix plays in the reports our investigators send to us. It's very important for us to understand both the intent and implementation of the matrix, and I submitted the matrix as this for a variety of good reasons. Soon it'll be time to reflect on whether there are new legislative proposals to consider, not for the current session, which is grinding toward adjournment at the Capitol, but in relation to the short session in February 2026, as well as the next longer one in 2027. A probable topic for 2026 could deal with issues involving the League of Oregon Cities and public meetings law enforcement, which Director Myers will cover in a report later in the agenda, and for which there are documents in your file that you might have read in advance. Other topics also might be possible, such as, to reiterate one of my notions, it may be time for us to think about gaining the authority to issue letters of education on the basis of preliminary reviews without having to go into investigations to issue such letters. We can think about that down the road. Any comments from colleagues on other legislative issues heading toward 2026? Anybody? Commissioner Mason, any thoughts?
Commissioner.
I know. Commissioner
Yeah,
Mason
no,
has
I expressed to the executive director and yourself, I think that we should be pursuing a higher overall penalty per violation. And I think that other states have a higher penalty amount per violation. I think it would be in light of some of our recent cases. I think that's something that definitely needs to be reviewed. Obviously, the commission has the discretion to go up to a max penalty, but I think a max penalty of $5,000 should be addressed by the legislature, and I think it'd be smart for our staff to promote that idea to the next or the next legislative session. I know it's going to be a short session, but I also understand that might be the best opportunity to see something improve with the legislators in a election year. But that's just my own opinion. Thank you.
Thank you, Commissioner. Appreciate it. Commissioner Burke, I see your hand. Please proceed.
Thank you, Mr. Chairman. Very briefly, I want to express my appreciation for you bringing up these possible topics. Things move fast at the legislature. Circumstances can change quickly. And I think that our executive directors, current and past, have done a very good job of representing the board and its interest to the legislature. But I think given these fast changing times and circumstances, we need to be a little more involved and a little more proactive in helping to shape the board or excuse me, the commission and its mission. So I look forward to all of us being more proactive along those lines. It's a great idea, and I thank you very much for bringing that up.
Commissioner, thank you. On this issue, if we agree on ideas, the role of staff is to bring more clarity to a proposal before gaining our concurrence and then asking the governor for permission to introduce a bill or bills for us in whatever session 2026, 2027. So seeing no other hands,
Real quick,
Mason, please.
Chair,
Please,
clarify. Thank you, Chair. On clarification, do you have to have permission from the governor to advance something that would within the Ethics Commission? And I just asked that because I thought that we were semi-independent from the governor's office.
The answer, Commissioner Mason, thanks for asking the answer, and I'm seeing the head nod in the affirmative from our executive, Ms. Myers, is that we do need the governor's approval to introduce bills for us in the session. The governor authorized the introduction of the 5 bills this session in 2025, for example, Director?
That is correct.
And that's a procedural thing on one hand, but that's also a relationship any state agency has with a governor by extension or in fact. So we will go through that process. Thank you, Commissioner. Moving on, the agenda for the public session also allows for general comments from commissioners on subjects not on the formal agenda. So any takers this morning? General comments before we move into the agenda? Thank you. Hearing and seeing none, we'll consider the minutes of the May 9th, 2025 meeting. Those minutes have been distributed to all of you. Any comments on those minutes as you received them? Hearing and seeing none, so I'll take a motion to adopt them as distributed. Vice Chair, please.
Thank you, Chair. I move that the commission adopt the minutes of the May 9th, 2025 meeting.
Thank you, Vice Chair. Whatever you said, I appreciate it. Thank you very much. Any comments on the motion? Hearing and seeing none, the administrator will call the roll, please, on the minutes of May 9, 2025.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
I abstain because I was not present.
Commissioner Mettler.
Aye.
Commissioner Mason.
Aye.
Chair Piscom.
Aye.
Motion passed 7-0 with 1 abstention.
Hey, colleagues, the approach this morning that we'll undertake in a moment is the following. We'll consider 2 stipulated in the public session. We'll consider 2 stipulated final orders on that agenda, items number 55 and 56, or perhaps better put for the record, items 23-067 and item 24-424. Plus, after considering those issues, we will also consider on your agenda, public session agenda item 57, numbered 24-281, involving Mr. John West and his counsel, Connor King. That said, I'll wait for the staff to indicate that we're ready to proceed with items 55 and 56 on the public session agenda. And we will admit individuals who want to speak to us on at least the first matter, 55.
We could, Chair, are we gonna consider the stipulated final order consent calendar first while we get folks in the room?
We can do that.
Thank you.
Thank you for the question. The issue is now we'll consider first the consent calendar on our public session agenda before we move to those issues that were mentioned. So the consent calendar, anybody, first of all, want to remove an item from that consent calendar to be considered individually. The consent calendar that you see in your public session agenda, consent calendar, etc., items 4 through 36.
No, Chair, on the stipulated final order consent calendar, which starts item 49.
Please proceed.
Okay, so I need to let everyone know we have pulled items 49, 50, 51, and 52 off the agenda. So those will not be considered as part of the consent calendar. We will revisit those at a future meeting.
Thank you for that.
Stipulated final order consent calendar consists only of items 53 and 54.
What about the consent calendar items 4 through 36?
We can consider those now if you wish.
Okay, Vice Chair, let's consider items 4 through 36, the consent calendar, before I seek a motion. Is there anybody on any of those named individuals in those matters want to pull a name off the agenda, off the consent calendar to consider it individually? Hearing and seeing none, Vice Chair, please, the consent calendar items 4 through 36.
I move that the commission approve the consent calendar as presented.
Thank you, Vice Chair. You've heard the motion. Any questions? Hearing and seeing none, the administrator will call the roll on that motion, please.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Colleagues, one more item on the consent calendar. If you look at your agenda, this will pertain, unless I'm corrected, to item 53 and 54. It's stipulated final orders on the consent calendar. Does anybody want to pull either of those off the consent calendar, those two items? Hearing and seeing none, Vice Chair, please.
I move the commission approve the proposed stipulated final orders presented on the consent calendar as the final orders in those cases, and the chairperson be authorized to sign them as such.
Heard the motion. Any questions? Hearing and seeing none, the administrator will call the roll, please, on that motion.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Thank you, colleagues, and thank you for the reminder to do the consent calendar. We will now, as soon as we're ready from a technology perspective, move to item 55.
Yes, the attorney for the respondent in 55 is online, Mr. Steringer.
Mr. Steringer, welcome again. May I say this, it's good to see you again back before us. Thank you for your participation today. The time has now come on our agenda to consider the stipulated final order involving Mr. Steve Marks, your client. I believe Mr. Marks, Mr. Steringer is not appearing.
That's correct, Chair Fiscom.
Thank you very much. Okay, let's begin on this item. We're hearing our staff report from the executive, Susan Myers. Please proceed, item 55.
Thank you, Chair Fiscum, Commissioners. Item 55 is a proposed stipulated final order for Steve Marks, the former executive director of the Oregon Liquor and Cannabis Commission. As you will recall, this matter came before you at the last meeting, and the consensus of the commission was that the proposed penalty was inadequate in light of his position and other factors. You directed us to go back and see if we could renegotiate, and we did so. The stipulation that's before you now proposes a civil penalty of $1,500. And basically, this negotiation between Bob and I, there was only one bottle that we can prove no more than one bottle, and he did purchase the bottle. The $1,500 penalty represents 5 times the actual amount that he paid for this bottle of Pappy Van Winkle. It also represents 3 times more than what the prior settlements of other people involved in the OLCC cases were. So I think it is an appropriate resolution, given that it's one bottle, and recognizing that he was the director, and as you say, is held to a higher standard.
Thank you, Director. Appreciate the comments. Colleagues, any questions in light of what the director has said before I turn to Mr. Sterringer for his remarks? Questions, comments, concerns, issues? Hearing and seeing none, Mr. Sterringer, this is your time to make any comments to us you choose to make. Thank you for being here. Identify yourself for the record and proceed.
Good morning. Thank you, Chair Fiscum, members of the commission. Bob Sterringer of Wranglong PC. I represent Mr. Marks. My remarks are very short, actually. I think we heard from the commission at your last meeting. We understood the message that we were given. We went to work to try to resolve the concerns that were raised. And Executive Director Myers identified all of the points that I would have made. And so given your busy schedule, I will just ask that the commission accept this proposed stipulated final order, and I'd be happy to answer any questions that the commission might have.
Thank you, Mr. Sterringer, and thank you again for being here this morning. Colleagues, any questions for Mr. Sterringer based on his remarks? Now is the time if you have any questions worth asking Mr. Sterringer. Hearing and seeing none, colleagues, the time now comes for us to decide how to proceed on this matter. I'm open to any comments anybody chooses to make before I seek a motion. Commissioner Mason, please.
Yeah, obviously, the previous meeting, I definitely advocated for a change in the number, and I appreciate the staff for doing that. I appreciate the work that took place. I think based on what the executive director stated with the one provable situation, and the fact that it's 3 times the original violation and 5 times the original dollar amount, I would support this and go back to some of my previous comments that, we should always be looking at a top official for a top penalty. And I think based on our last meeting, some of the other cases that were involved, I think this is an appropriate number. Thank you.
Commissioner Gutierrez, please.
Yes, thank you, Chair. I don't agree with the recommendation. I think that the penalty should be significantly higher. And the reasons for that is this is an agency director. I don't believe that he only took one bottle or paid for one bottle. I think there's some serious issues here, and he needs to be held accountable for what he did. And there has been, regardless of whether it's a part of the matrix or not, there's been no remorse that I can see here compared to other cases. And I think that if we were to take this through, that we would be able to show that there's more of an issue here than just one bottle. So my recommendation would be that we go for the full penalty, the maximum, but no lower than 3,600.
Commissioner, I appreciate your comments. Other comments, commissioners? Commissioner Thompson, please.
Thank you, Mr. Chair. I appreciate the work that the staff has done on this. I echo many of Commissioner Mason's comments. I'm prepared to accept this number based on the factors that have been discussed, but also the overriding factor to me is that the bottle was paid for. I mean, it wasn't like it was some of the other cases where it was taken. And I'm also not immune to the feedback we've gotten on some of our other decisions, dollar wise, but I would respond to those in two ways. First of all, we're governed by limits. And second of all, I think that we have to be consistent. I think we have to be able to justify based on other cases what we're doing. But finally, the overriding thing for me is, especially in the current fine environment, there's no fine that we can impose greater than these public officials, what they went through in the press, and losing their jobs. I mean, even if we impose the max penalty, I mean, they lost their jobs and all that came with that. So I think the finding of the violation, I think the fine in light of the other fines we've given is fair, and I'm prepared to support it.
Commissioner, thank you. Colleagues, any other comments? Commissioner Burke, I see your hand, please.
Yep, just very quickly. I would not want to bet my life that only one bottle was involved here, as one of the other commissioners may have noted, but we can't prove that. And I don't think it's good for us to start getting into suspecting or basing penalties on what we think they might have done, in addition to what have been proven by the good work of our staff. So for this reason, I support the number.
Commissioner Gutierrez, please. I see your hand again.
Thank you, Chair. Well, I want to clarify. I mean, he didn't talk to us, right? Directly? And speak as to the, I mean, am I wrong in the investigation report that he did not actually speak to us as to and confirm the number?
I'll turn to the executive to make a quick comment, make comments in response to your question, Commissioner. I would only add, I know you couldn't be at the last meeting and excused absence, but at the last meeting, Mr. Steringer spoke and Mr. Marks also spoke briefly to us online. Just for the record, that happened, and I'm not trying to recount what was said, but he did appear before us. Director, please.
Yes. So during the investigation, while we can request an interview, when there were pending criminal investigations, and the nature of the Department of Justice report that was issued did leave open the potential for further criminal review or investigation should new information come to light, which creates a problem for us. He has a Fifth Amendment right. We cannot compel him to speak adversely. So as a result, the only evidence that we have available to us is those original interviews that were conducted at OLCC, where he acknowledged the receipt of the one bottle. The additional matter to consider is what DOJ found in its investigation was that the tracking systems, there basically are three at issue at OLCC for the inventory that is kept in the warehouse and when it gets transferred to the liquor stores, and then the point of sale information at the liquor stores is not conducive for tracing this person bought this bottle on this date here. So really the only evidence we have is his original interview.
Right. Thank you, Director.
Any follow-up?
Well,
Any
I just
follow-up?
want to say thank you. I appreciate that. And that's what I was getting at. I'm not saying that he needed to be compelled to testify or present more testimony, but we are operating with limited facts. And what I'm saying is that if this were to go through the entire way, that there might be more evidence that comes to light. I appreciate the work of the commission, especially the executive director and the staff. But I just want to be very clear that I don't think this sort of losing your job, yes, but this sort of behavior should not be tolerated by people in high positions of government, especially given the current climate.
Hey, Commissioner, any other comments, colleagues? Seeing no hands, I'm going to exercise the prerogative of the chair and see if Mr. Sterringer wants to add anything before we move toward a decision. If you do, Mr. Sterringer, now's the time. You feel no pressure unless you want to.
Thank you, Chair Fiscom. I appreciate that, but I do not have further comments.
Thank you. Colleagues, now's the time to discuss a decision process here. We've had some comments already from colleagues, my colleagues. I'm Vice Chair, are you ready to make a motion? If you are,
I
please
am.
proceed.
I am. Thank you, Chair. I move that the commission approve the proposed stipulated final order as the final order in this matter, agenda item 55, Steve Marks, and the chairperson be authorized to sign it as such.
Colleagues, you've heard the motion to affirm the recommendation of the STIP. Any comments on that? Further comments on that? Hearing and seeing none on item 55, the administrator on our public session agenda, the administrator will call the roll. Please proceed.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Nay.
Commissioner Mettler.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Chair Fiscom.
Aye.
Motion passed 7-1.
Thank you, colleagues. Thank you for the clarity of your comments along the way. Mr. Sterringer, thank you for appearing today and you taking notes I saw and you saw the results. So we'll be in touch with you officially with that by letter, but thank you for your appearance today.
Thank you.
Hey, colleagues, we're now going to move on still on the public session agenda to item number 56. The individual involved is Dina Ferguson is not appearing today. So the process will be that our investigator, Mr. Pacheco, will make a report to us before our decision. Please proceed.
Thank you, Chair Fiscom and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 56 in your meeting book is a stipulated final order for Dina Ferguson, manager for the South County Health District. On December 13, 2024, the Commission voted to move this matter to investigation to determine if Ms. Ferguson had violated the provisions in ORS Chapter 244. In the preliminary review report, it appeared that Ms. Ferguson had failed to declare a conflict of interest and used her position when she made recommendations and took action on matters concerning property owned by her parents, known as the Clark property. During the investigation phase, Commission staff were able to verify Ms. Ferguson's violation of ORS 244.040 sub 1 and 244.120 sub 1C based on district materials and information provided by Ms. Ferguson. Ms. Ferguson has agreed and indicated that she wishes to conclude this matter and has signed the stipulated final order. The order in your meeting book provides that Ms. Ferguson will pay a civil penalty in the amount of $750. We are recommending that the Commission approve the stipulated final order. Thank you.
Investigator, appreciate your comment, your report. Any comments or questions for our investigator, Mr. Pacheco? If so, now's the time. Hearing and seeing none, we'll proceed toward a decision. Any comments on how we ought to proceed in this matter, colleagues? Hearing and seeing none, Vice Chair, are you ready to make a motion? Please, if you are, please proceed.
I move that the commission approve the proposed stipulated final order as the final order in this matter for agenda item 56, Adina Ferguson, and that the chairperson be authorized to sign it as such.
Heard the motion, colleagues. Any questions? Hearing and seeing none, the administrator will call the roll. Item 5-6.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Mettler.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Thank you, colleagues. We'll now move to one more item on the public session agenda, number 57, involving Mr. John West, the former Josephine County Commissioner, and his counsel is Mr. Connor King. Let me know when one or both of them are online. Staff?
Right there. Both,
Mr. King, welcome. I see you now. Thank you.
and the respondent is online as well on the phone.
Mr. West, can you hear me? Mr. West, you may be muted. Can you hear me?
*6 to unmute.
*6 to unmute on your phone. Mr. West, can you hear me yet? You wait a
Yes, sir.
second.
I'm here, I believe.
Oh, thank you very much, Mr. West. We'll proceed. Mr. King, can you hear me?
I can hear you.
Thank you. The time has now come to consider this item on our public session agenda, which is number 57, dealing with Mr. John West, former commissioner, Josephine County Commission, as well as his counsel, Mr. King. Our process will be to hear first from our investigator, Mr. Sullivan, a report on this matter before us. Please proceed, Mr. Sullivan.
Yes, thank you, Chair Piscom and Commission. This is Investigator Josh Sullivan for the record. I'm presenting agenda item number 57. This is a complaint against John West, former chair of the Josephine County Board of Commissioners. The complaint in this case alleges that John West violated Oregon government ethics law by attempting to use his official position for financial gain and failing to publicly announce a conflict of interest. In this case, the Josephine County Board of Commissioners held a meeting on July 30th, 2024. John West began the meeting with a discussion about whether to continue, suspend, or reduce the Josephine County community development fees. John West discussed the necessity of the fee with the community development director and suggested the possibility of restructuring or pausing it. John West's initiation of the board's discussion of the community development fees at the July 30th meeting appears to be for the purpose of having the board consider future action. John West and his business, Axis Development, have applied for 5 residential building permits since 2017, accruing a total of $3,035 in community development fees. And as a property developer who has a history of applying for building permits, which include payments for community development fees, and the owner of 15 properties within Josephine County, John West could reasonably expect a change or pause to community development fees to directly affect him or his businesses. While John West's property development businesses do not typically apply for residential building permits, the community development fees could make parcels in Josephine County, such as those owned by John West or his businesses, more appealing and could lead to a greater demand and higher sales prices. Thus, John West was met with a potential conflict of interest at the board's July 30th meeting. However, he did not publicly announce his potential conflict of interest. When this case was moved to investigation, one of the primary purposes was to examine whether John West is part of a class which would exempt him from the conflict of interest requirements. John West states that he is part of a class of homeowners and property developers within Josephine County who would be equally affected by changes to community development fees. Only the commission may identify the classes that qualify under this exception, the membership of those classes, and whether specific members would be affected to the same degree as all other members of the class. The commission could identify a class of homeowners in Josephine County who would be proportionately affected by changes to community development fees, including building permits. Additionally, the commission could identify a class which includes businesses and property developers. It appears that each property development business could be uniquely affected by a change to community development fees, depending on the size and scope of their property development projects. However, it also appears that community development fees are uniformly charged as 1% fee in accordance with statewide fee methodology. It should also be noted that after this case was opened, Josephine County Legal Counsel made a request for a similar class exception determination. Addressing the prohibited use of office, because John West and his businesses own multiple properties within Josephine County, which are subject to local regulatory taxes and fees, it appears John West attempted to obtain
financial gain when he used his position as a county commissioner to suggest a restructuring of the community development fee. And by doing so, he engaged in a prohibited use of office. The class exception may apply to the conflict of interest portion of this case, but it does not apply to violations of ORS 244040. The recommendation is that the Oregon Government Ethics Commission should make a preliminary finding that John West violated the prohibited use of office provision in Oregon government ethics law. Unless the commission determines that the class exception applies, the recommendation is also that the commission should make a preliminary finding that John West violated the conflict of interest provisions in government ethics law and further order that the case be moved to a contested case proceeding or that a negotiated settlement be entered.
Investigator, appreciate your report. I have a quick question, but I'll yield to my colleagues in case there are questions for our investigator. I have a question related to the class exception, and if I've asked this before, I apologize before I ask it again. As a commission, we have not taken any steps in this matter to decide that there is a class. That is a step we would have had to have taken before this item came up or after this item comes up. We have not taken any step to establish a class. Am I right in that?
No, in advance of the case, no, there was no determination made as to what classes there could be.
Right.
That is what is before the commission right now. You can make that determination as part of your decision in the case. Keep in mind, there may be multiple classes. In any case, there could be multiple classes. Here, there's a class of homeowners who might be applying for the permits, but that does not mean that the property developers and construction companies and land clearing companies are part of that class. They would be a separate class, and so the commission would need to make a determination. Would the class exception apply to both or only to the homeowners? And that determination is based on, would the effects of canceling or suspending these fees affect all members of each of these separate classes to the same degree or proportion?
Thank you, Director. A quick follow-up, and I'll see if my colleagues, I don't want to step on anybody's line here, but to go through would there be a process we would need to go through as a commission with staff to establish a class? It's not something we could simply do upon hearing a report to establish a class. Would we not have to go through some kind of a process to get more information of a detailed character before making such a decision? Friendly question.
Yes, but the information for that was what Josh and I did. And so that is in the report that's before you.
Okay, thank you. Colleagues, any questions for our investigator and or the executive?
Yes, Chair, I have a question.
Chair, please, Vice Chair.
Thank you, Chair Fiscum. This is a question for Executive Director Meyer or the investigator. I do see in the report, and you just mentioned this, that there could be a class of homeowners, but respondent would not be part of that class of homeowners. And so in order for the class exception to apply, it seems that we need to find that the class would be businesses or property developers. And however, it seems that your finding is that that class could be affected differently depending on the work done by the business. So it wouldn't necessarily impact that class proportionally or on the same basis. Am I understanding that correctly?
Yes, so the respondent, Mr. West, could be a member of the homeowner class too. He owns homes. He's gotten the permits for his own property actions. And so the class exception could apply to him as the homeowner, but may not apply to him as property developer because they are two separate classes.
So just to follow up, even if we were to find that the class exception applied to homeowners, because he was also a property developer in this situation, that finding would not necessarily resolve the conflict of interest issue, correct?
That is correct.
Thank you, Vice Chair. Director, any other questions before we proceed? For the moment, hearing and seeing none, Mr. West, Mr. King, this is your chance to make any comment you choose to make to us. Please do so for the record and choose the order in which you want to appear before us at your choice and identify yourself for the record. Please proceed. Thank you.
Thank you, commissioners. My name is Connor King. I'm counsel for John West, appearing this morning. And I wanted to say thank you first for being flexible and hearing this matter right now to accommodate my own busy schedule. I have a couple of comments. I'll try to make it start with kind of a summary. But initially, I think that talking about the class exception is kind of putting the cart before the horse, because I don't think this meeting was about taking any actions in the first place. This meeting was a purely informational meeting. Mr. West had received complaints from community members about the fee. He didn't know what it was even really about, which is why they brought in Mark Stevenson, who is part of the building department, and to ask him, what is this fee? I mean, what's going on here? And this meeting was purely informational. It was listed as, pause on community development fee, but that was only because they were concerned that, they didn't know what this fee was about and that it might have been, unlawful. And so they had the county legal counsel there attending with them as they were gathering information from Mark Stevenson about what this fee was. They didn't make any recommendations. They didn't even necessarily consider further action. It was purely information gathering, as Mr. West and the other commissioners didn't have an understanding of what this fee even was, which, not knowing what the fee is, makes it difficult to even consider whether something would be a conflict of interest, related to this fee. It also makes sense that Mr. West didn't really have an idea of what this fee was, since it's not a part of his business. He's a dirt mover, basically, developing properties before they even go to the stage of construction where these kind of permits are obtained. He's gotten, I think 4, it is, I think it's 4 or 5 permits that include this development fee since 2017. So in the past 8 years, and in the past 5 years, only 1, and that was to help his daughter. His daughter was building a home, and he helped pull the permit for her to help her navigate the process. He didn't know there was a community development fee attached to that permit, so I think the discussing the potential for a class exception is kind of putting the cart before the horse here, because I don't think there's a conflict of interest in the first place. But to move on with sort of the summary, I think the report and the investigative report, like the preliminary report, I think it does some mischaracterization of Mr. West's comments during the meeting. Mr. West did, he was very clearly, if you listen to the recording, he was very, when he's talking about, my property, that kind of thing, he's talking specifically with relation to the concerned citizen complaints. He's reading from those, saying, well, if I had this, $1,300 bill, I would wonder where it was from. That is what he is talking about. He wasn't talking about his own property. Mark Stevenson tried to bring up Mr. West's property on multiple occasions, but Mr. West didn't engage in that. He didn't even have an idea of how it might affect any properties related to his own business, and he wasn't trying to ascertain that during the meeting. It's pretty clear from the recording. He also, as I mentioned, his businesses and him personally do not obtain the kind of permits that were being discussed here in the ordinary course of his business. And as already I mentioned, county legal counsel was there during the meeting because this meeting was for the purposes of gathering information about this fee that some concerned citizens had come to Mr. West to ask about. And so that it was purely information gathering. Let's see here. Mr. West doesn't even have a contractor's license, and his businesses don't either. They don't do that kind of construction work that would be required for these kind of permits. And then with respect to the class exception, if Mr. West would be considered a part of the sort of industry of property developers, he would be affected. Maybe it would affect businesses differently. Some obtain more permits than others. Certainly, he would be affected least of all property developers in that class, since he never obtains those permits at all. It's also hard to imagine that there's any significant or even de minimis impact on the appeal of the lots for sale. If there even was a pause on the community development fee, we're talking about a couple $100s for homes that sell for hundreds of thousands of dollars. And these are not even, Mr. West wasn't even engaged in selling lots during the time that he was a commissioner. And then with respect to the idea of being a class, part of a class of homeowners, these permits apply to, every remodel, building a garage, even building dog houses comes under this. Any kind, there are homeowners that have applied for multiple permits, more than John West, and they only own one home. This kind of permit, it was something that Mr. West wasn't even aware of beforehand. And then let me look at my notes real quick to make sure I'm not missing anything else that I wanted to mention.
Mr. King, please do that for the moment. And meanwhile, if you'll allow me this indulgence, I'll turn to your client, Mr. West, in case he has any remarks to make before coming back to you one more time. Mr. West, any comments to make? And if you do,
yes.
Now's your time. Identify yourself for the record. Please proceed as briefly as you can. Thank you.
Yes, sir. Yes, sir. John West, former county commissioner, Josephine County. I just like to reiterate what Mr. King said. I had multiple homeowners and people contact me about a 1% fee on their building permits. And so I had asked about it, and I didn't know if I was getting the right answer. So I just put it on the agenda so the whole board could hear it, and we could have legal counsel look at it and decide whether Josephine County was doing it properly. And so I had brought forward a couple of different illustrations, and one was a building permit fee that a guy got for a greenhouse, paid $2,500 extra for the 1% fee for his greenhouse. And another one was a homeowner they built a house, and it was $2,300 1% fee it equaled. And one of my questions that I always had was, the state statute says that you can't charge more than the cost of a fee can't be for more than cost of service. And because this was on their building permits, I couldn't figure out why a planning fee was on a building permit when planning fees are totally separate from building fees. And they're two different fees, and you pay your planning fees one time and then you pay your building fees. And so that way it was just to have as the discussion point to figure out. I wanted to make sure that the county wasn't liable for this $823,000 that had been collected the previous year in this 1% fee. And the board listened to it. We talked about it. But we never come to any conclusion, and it still hasn't been resolved today, even with the new board. And so it was just because landowners had brought it to me, I wanted to know that I understood it and could give them the right answer. As far as myself and my companies, I don't have a contractor's license. I don't build houses. I don't build houses for other people. I helped my daughter one time. She was a general on that. I just took her down to the building department, said, this is where you go, and you go to the building department here, you go and get your permits here. And besides my own house, I don't build for other people. So I'm not a builder. I'm not a contractor. I don't have a contractor's license for even moving dirt work and doing other stuff for other people. I only do it for myself. And so this wasn't something there was no decision made. It was just to gather information to find out if the county had liability or if we were doing it correct, or to understand what this 1% planning fee on a building, on your building permit was for. That was all it was. It was never to, nothing was resolved. It just never got resolved. We just got information. That's all it was. I think that's all I have to say.
Thank you, Mr. West. Mr. King, any last comments quickly for the record, if any?
Yes, really quickly. The definition of action, it's not, I don't think it's specifically defined in ORS 244.020 sub 1 or sub 13. You know, I don't think it's in that definition sections it's defined, but I believe it's discussed in the guidelines for Oregon government ethics issued by the DOJ, and it typically means any decision or recommendation made during a meeting. I think any reading of this meeting that applies the word action to it is quite broad, and I think inapplicable, which is why I say this is putting the cart before the horse to talk about classes, because I don't even think we're talking about a conflict of interest here. I mean, we're talking about trying to understand what this thing even is in the first place. And you know, even finding out what it is, it's hard to imagine how this affects Mr. West directly, since he or neither he nor his businesses engage in pulling these permits on a regular basis. These permits were personal and no different than any other homeowner. So that's I think all I have to say on that matter, but I'm happy to take questions if you have any.
Thank you, sir. Appreciate your comments. For the record, now's the time, colleagues, if you have any questions for Mr. West or Mr. King, to pose them at this moment. Please proceed. Anybody? I see no hands at the moment. Any questions? Hearing and seeing none, the time comes for us to make a decision on this matter in light of what you've heard from our investigator as well as the respondents. I'm open to comments on how we ought to proceed today or how individual commissioners think we ought to proceed. Any comments? Hearing and seeing none, Commissioner Thompson, please.
Thank you. I'm not sure there's any here. I feel like the commissioner got some questions. He held an informational hearing to answer some questions from constituents. They didn't vote. They didn't take any action. I guess unless I'm missing something, I just don't see the violation.
Thank you, Commissioner. Colleagues, any response to Mr. Thompson's comment? Executive, any comments in response? And if you don't, that's okay. No pressure. Thank you. Colleagues, how do you want to proceed? I'm open to suggestions before I seek a motion. We have one comment that raises a question about whether there's, to quote my colleague, any here, quote, end quote. Okay, Commissioner Burke, please, I see your hand.
Yeah, thank you very much, Mr. Chair. I'm kind of the same mind as Commissioner Thompson. I think one thing that would be helpful in cases like this is if there were a legal definition of what taking action means. But absent such a definition and not seeing any clear, what I would regard as an action, I would have to agree with Commissioner Thompson.
Commissioner, executive or counsel, in law or in guidance on the law, is there any definition of the word action? It's been referred to by our respondent to Mr. King, but I'm interested in any reactions. Please proceed, each one of you.
Yeah, I was just going to say, so that's a public meetings issue, not a, and that's not the allegation. So there's no reason to get into whether or not action means something in this particular context or not. The question is, was there a conflict of interest? Was there a use of office? Not whether or not there was a public meeting. It was a public meeting, but that's beside the point.
Thank you, counsel. Executive.
one thing I would stress is public officials take actions in many different ways. It's not only in the public meeting, you know. When I decide what to order lunch,
That's an.
I'm taking an action. So Mr. West can take actions at the meeting in terms of information gathering that on the public meeting side is part of the entire decision-making process. And conflict of interest applies to making decisions, recommendations, or taking actions.
Thank you. Colleagues, any further questions? Commissioner Burke, your hand may still be up.
Thank you very much. As I understand from what I've read and from what I've heard, it was not clear going in or that he was aware that there was a conflict of interest. I'm wondering if there is anything on that I've missed.
Executive, investigator, any reaction to our comment?
I'm not an attorney, so I'm always double guessing myself on these kind of things.
Okay, Commissioner Burke. So the public official, anyone is responsible to make the determination before they take action, make a decision, or make a recommendation. They need to evaluate their own circumstances and determine whether they could have or would have actual or potential conflict, and then make their disclosures.
Thank you.
Thank you.
Hey, colleagues, Vice Chair, please.
Thank you, Chair. Because this is a potential conflict of interest disclosure and not an actual conflict of interest disclosure violation, deliberation, as I understand it, deliberating on the matter, there would still need to be a potential conflict of interest disclosure. And so I'm leaning towards finding a violation here for that purpose, even though no decision or vote was made at that particular meeting. And I, for the reasons I said earlier, wouldn't likely find a class exception that would alleviate that conflict of interest.
Thank you, Vice Chair. Further comments, questions, reactions? Hearing and seeing none for the moment, I'm looking for a motion from somebody who chooses to make a motion.
I'm happy to make a
Vice Chair,
motion, but I will
Chair.
defer to Commissioner Burke or Commissioner Thompson if they would like to make a motion first, since we differ on our views on this one.
Thank you for that comment. That's what I was going to say. You said it better than I would have said it, so thank you for deferring. Mr. Thompson.
Mr. Chair, I just want to clarify that I don't necessarily disagree. I just wanted some clarifying. I guess I just needed things to be clarified in my mind. And I appreciate Commissioner Payne for the deference, but I'm fine.
Thank you. Commissioner Thompson, you were prepared to make a motion?
Sure, why not? For agenda item 57, I move the commission dismiss the complaint against John West.
Colleagues, you've heard the motion that now has been made by one of our colleagues. Any questions on the motion? For the moment, hearing and seeing none, the administrator will call the roll on item 57. The motion is to dismiss. Please proceed.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
No.
Chair Fiscum.
No. Vote on the motion 5-2, am I right?
6-2.
6-2, thank you very much. So by vote, Mr. King and Mr. West, this matter has been dismissed. You will hear officially from the commission about this decision. We'll send you a letter in writing. Thank you for participating this morning, and thank you for your comments. We appreciate it for the record.
Thank you, commissioners.
Thank you.
Thank you.
Okay, colleagues, we're going to forge ahead with your indulgence. Let me make a couple comments as we head toward the executive session. First comment is, do any of the commissioners need to declare a potential or actual conflict of interest pertaining to a matter on the executive session agenda? And if so, now is the time to make such a declaration during the public session. Commissioner Gutierrez, I think you have a declaration.
I do. Thank you, Chair. So I need to declare a potential conflict of interest as to the following items on the executive session agenda. And I understand that I think at least two of them are on the consent calendar. Because my law firm, Miller & Ash LLP, represents the entities in these, not with regards to these matters, but referenced in the matters. So that's numbers 2, that's 25-290 PCF. Number 3 in the consent calendar, that's 25-29 3 PCF. And then on the reports for preliminary review, am I going at the right pace here, Susan?
Yeah.
Please.
Great. City of Salem, number 6, that's 25-159 PJS. And that applies as well to 7, 8, 9, 10, 11, 12, and 13. And the last one is number 26, which is 25-037 LAM, regarding Immigrant and Refugee Community Organization, also known as IRCO.
Commissioner, for the record, appreciate that clarity. Colleagues, executive, have you followed all that? For the record, I know you have. Okay, any other declarations, colleagues? Please proceed. Go ahead. Executive?
No.
Okay. Second, our staff is maintaining a list of representatives from the media who have told us they intend to attend the executive session under provisions of state law. Are there any questions about the list before we move into executive session?
Sure, I do have one caller that I have a couple folks who have joined who we are unsure of their identity. So I would, with your permission, like to have them identify themselves.
Please proceed.
Thank you. Caller who has phone number ends in 4421. Can you please hit *6 and identify yourself?
Hello.
Hello, can you please identify yourself?
My name is Chris Bristol, and I'm with the Daily Courier newspaper in Grants Pass.
Thank you, sir. Appreciate it. One more, maybe?
Yes, just
please.
We have someone who joined as meeting guest unverified. I have given you permission to turn on your mic to identify yourself. You joined via Teams and your ID is meeting guest unverified.
That may be me. I'm Diane Taniguchi Dennis.
Thank you, Ms. Taniguchi Dennis. I'm going to read something which will mean that you'll be removed from the virtual lobby for some time until the item involving you comes up on our agenda. So, colleagues, there's one more maybe on the media.
Yes.
Please proceed.
I apologize.
No.
So this individual joined via Teams and identified themselves as S, and that is it. I have given you permission to unmute yourself. Can you please identify yourself?
Did quote S unquote hear that request? Hearing and seeing none, let's remove that individual from the executive session.
Thank you, Chair. That is everyone that I cannot identify online.
Thank you for that work. Appreciate that. Now let's move to executive session, but let me make this brief reminder again for all of us. Please limit side conversations because our technology is sensitive enough that it can pick up those conversations and then they can become part of the official record. And before the doors, both on-site and virtually, are closed, I'll read for the record the specific statutory authority that enables us to proceed in this way. And as I've often said, credit goes to our staff and council for drafting this authority with appropriate specificity. Here is the script. Bear with me. The Oregon Government Ethics Commission will now meet in an executive session to consider preliminary reviews. Representatives of the news media and designated staff shall be allowed to attend the executive session. When we enter executive session, all other members of the audience will be asked to leave the room, either virtually, everyone currently joining the meeting online and over the phone, other than representatives of the news media, will be removed from the meeting. If your case is being heard in executive session, you will need to rejoin the meeting where you will be held in the virtual waiting room until the commission is ready to hear your case. Our staff will text you on the number you have provided them to let you know when we are about to hear your case. The executive session is being held under ORS 192.660 sub 2 sub F and ORS 244.260 sub 4, ORS 171.778 sub 4, and ORS 192.685 sub 1 to conduct preliminary reviews of ethics, lobby, and public meetings law complaints. Representatives of the news media are specifically directed that after the commission has made its determinations and adjourned to the executive session, they may report on their preliminary review cases considered in executive session, including the commission's deliberations and its final determinations. ORS 244.260 sub 4 sub D sub C and ORS 171.778 sub 4 sub D authorize the commission to deliberate and make its final determinations on preliminary reviews in executive session. Following the conclusion of the meeting, the commission will publicly disclose and post the audio and visual recordings of the preliminary review executive session. Once the executive session is concluded, we will return to open session and welcome the audience back into the room. There are two things we need to address before entering the executive session, both of which I think we've addressed. First, if conflicts of interest need to be disclosed, one of our commissioners has done so. And second, I think we've dealt with the issues about the media attendance at this executive session. So that said, let's convene the executive session meeting for the date of June 13, 2025. That said, folks in the room, you can stand in our actual lobby until your matter comes up. The virtual lobby will be created for others. That said, the door will be closed in just a moment. Thank you for participating in this process with us. Colleagues, that said, on the executive session, our intent is to move through items as best we can in the order that they appear on your agenda, unless we get advised otherwise. So we'll proceed through the executive session consent calendar.
We are still working on clearing the room.
Oh, thank you
Sorry.
very much. Let's pause for a moment till our able staff says we're ready to proceed properly. So, thank you.
Yeah. I just need to switch over the recording.
Okay.